Welcome to Sakshi TV special immigration show with attorney Ms. Prashanthi Reddy from the Law Offices of Prashanthi Reddy PLLC. Please note that Sakshi TV now has 3 immigration shows every week. On Wednesday at 5:30 p.m. EST with attorney Ms. Prashanthi Reddy in English. On Thursday at 5:30 p.m. EST with attorney Chand Parvatneni. And on Friday at 6 p.m. with attorney Bhanu Idendra. Please tune in to ask your questions. If you're an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call 866-725-7441. Before we begin the show, please note that the information provided on this show is not a legal advice and is for general informational purposes only. Sakshi TV or its agents will not be responsible for use of information. If you need specific legal advice, please contact the attorney directly. Ms. Reddy needs no introduction. But if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, don't forget to mention Sakshi TV. From the beginning, reddyesq.com has put a wealth of free information and online tools in the hands of the immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies you don't have to be a lawyer to understand. And today's topic is the family-based immigration and what your options are. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we get into the topic, you can call us on the numbers displayed on the screen for questions related to immigration and also ask for tips. Hi, Ms. Reddy, how are you doing?
I'm good, Tony. How are you?
Very well, thank you. So, Ms. Reddy, today, before we get into the topic, would you want to discuss any latest immigration updates?
Yeah, so since it's the end of the year, it might be a good idea to do a recap, at least a recap from the USCIS point of view as to, what they have done throughout this year to 2022. So they have given us a nice update on what they think they have achieved. So there's some things that might be important. The rest are, it's just a lot of air, but we can dwell upon, some of the interesting things that they have said, just to give people a perspective as to how USCIS did in 2022, what, backlog reduction efforts they've achieved, how many cases they're approved, what new laws, if any, they have, established in order to reduce backlog, etc., reduce processing time. So I thought that would be a good thing to do since we're in December. So just to start, let's first talk about what USCIS did to reduce backlogs. So citizenship cases, they have significantly reduced the backlog compared to 2021. There were about 600,000 cases, and now there are about 200,000 cases. So definitely they have increased processing time. I mean, they have decreased processing time, and they've increased their productivity and increased the number of cases that they were able to approve in 2022. So that's good news. That's for citizenship cases. Making use of the available employment-based visa numbers. That has always been controversial because USCIS has always been faulted with not making use of available numbers. First of all, there is a backlog, and people from China and India have been waiting for years and years, and even when their date becomes current, they're unable to get their green card because USCIS is not able to process their cases fast enough before the fiscal year ends. So all those visa numbers which are available again become unavailable because they're not carried forward to the next year. So that's what's been happening last couple of years, but they are saying that in 2022 they have actually used up all the visa numbers. They used 275,111 green card numbers. Last year they used 195,000 green card numbers. The year before, in 2020, they used only 147,000 green card numbers. So, as you can see, quite a few, as per them, all the green card numbers have been used this year. So that's definitely good news. In addition to that, Also, EAD issuance, so employment authorization, has been a big problem because of the backlogs in 2021 and 2020 as well. So 2020, we saw EAD processing time skyrocketing to 10 months, 12 months, or sometimes longer. And so USCIS basically saying that they've been able to reduce the backlog for EADs as well. So as a comparison, in September 2021, they had a backlog of about 125,000, a little more than 125,000 EADs. Now they only have about 40,000 cases that need to be processed as of September 2022. So as we can see, they have been able to reduce the backlog, which is good news. So that's another, feather on their cap. Also, they're also talking about some new laws that they have implemented, which have helped again people who have suffered from backlogs. It has helped them to a certain extent. So we'll get into that a little later. But first, there is, a known labor shortage, especially for seasonal workers, agricultural workers, etc., and non-agricultural workers. So they have increased the numbers available for agricultural workers. Non-agricultural workers H2B to 64,000. Last year they only gave out 55,000. This year they've increased the numbers to 64,000. So that's also good news for those who file H2Bs, those employers who file H2Bs. Also, they have published a comprehensive menu of options available for STEM people in order to file O1 cases. So there's a detailed policy guidance on how people in the field of STEM can file an O1 non-migrant petition for under extraordinary ability. This is really not anything new. It's not a new law, but they're just explaining and they give examples of what can be applicable in a STEM field, because O1 is usually used in the arts and some other fields, but not so much in science. So that was a document that I don't know how useful it's been, but definitely an effort on their part to encourage more STEM people to file O1s. Also, authorizing spouses of E and L visa holders. Before, E dependents and L dependents had to get EADs, which was actually not the law, but USCIS was insisting on applying for an EAD, and we knew that EADs were taking so long, so a lot of people couldn't work. There was a gap in employment. They have authorized now this year E and Ls to work without the requirement of filing an EAD. So they're automatically authorized incidental to their status, which is the way it should be. So they've done that. They've made some reforms with EB5 category, which is the investor category. They've also made established a process for healthcare and childcare workers to make an expedited request for processing the initial EAD application if the EAD application has been pending for more than 90 days. So that's another thing that they've allowed them to file for expedite request. Also, expansion of premium processing. They haven't really done much of that, but we're hoping that something will happen next year. And of course, we should double the number of employment-based petitions, immigrant visas, as I discussed in in my earlier, when I was talking about that. Now, new commitments for 2023. So this is a promise kind of thing, a commitment that they're trying to make for 2023. This is certainly interesting. Implementing premium processing for all employer petitions. So that's good for immigrant, for all 5 I-140s, certain EADs, certain EADs for 765 students, as well as immigrant petitions, EADs. So they want to do premium processing for that, which is great. More money for them, and a lot of people will be benefited by premium processing application, because it's supposed to be processed in 30 days. Also, in addition to that, they've said removing the requirement for submitting biometrics whenever you file for a change or extension of non-immigrant statuses. So whenever you file an I-539 application, when you file an application for an F1 or a B2, they're asking for biometrics, which was not required earlier, but they started requiring it under the Trump administration, and so they're going to try to remove that next year. This will really simplify and decrease the processing time for I-539 applications. Right now it's 10 to 12 months, which is really a long time for a change of status application. Also, they've been talking about simplifying many of the forms so that the processing time is decreased. It's easier for automated processing. For example, the EAD application, they were saying that even a robot could look at it and auto generate look at the responses and kind of auto approve it with minimal supervision from an actual human being. This could really decrease the processing time for EADs, which is the I-765. They also want to simplify the 485. The 485 is very complicated right now, just by the way it's written and how things have been added over the years in a very jumbled fashion, haphazard fashion. So that could certainly help. Also, the citizenship application is, I think, far too long and with too much information required. So they want to simplify that as well. And that's good news as well. So there's no huge story here, but just gradual progress with reference to the problems that they're facing.
Right. So we've actually had a very detailed overview about how the year's been, and I think we've definitely seen some progress, if not an entire whoosh. I mean, at least we've seen a steady progress. So shall we proceed to the topic, Ms. Reddy?
Yes, sure. We did get sidetracked a little bit because this document was published today. So I thought, it's just hot off the press.
Yeah, of course.
We should talk about the processing times and stuff.
Of course.
So
yes.
Coming to the topic, family-based immigration.
Before we get into the details of the topic, and we have some FAQs ready for you as well. We have some questions that our viewers have asked, but before that, Ms. Reddy, could you lay the groundwork of what like a basic, probably beginning to what a family-based immigration is, and who can be a sponsor, if we can start off with the foundation.
Yeah, so basically family sponsorship is what it sounds like, meaning that you get a green card through a family member. So who can that family member be who can sponsor you? Or, so let's put it that way, who can sponsor you for a green card? So immediate relatives can sponsor you. So immediate relatives are children and parents, pretty much. They're the only immediate relatives. So, for example, so the good thing about immediate relative sponsorship is that there's no requirement for a visa number. Everything else requires a visa number availability in order to get a green card. And if there's no number, you just have to file the immigrant petition first and then wait. But here, for immediate relatives, there's always a visa number because there's no restriction on how many cases can be filed, unlike the other categories. So to start off with immediate relatives, so spouse of a US citizen can be sponsored, unmarried child of a US citizen under 21 years of age, a minor, an orphan of a US citizen, whether they're in the US or they're in India or abroad, parent of a US citizen, as long as the US citizen is over 21 years old. So these are the categories of immediate relative petitions that don't require a visa number. You can file immediately, and also in most instances, though you have to enter if you're in the United States and if you're out of status, this is the only category which can give you a green card. Otherwise, if you're out of status, you can't really get a green card in the US. But if you are related to an immediate relative citizen, then who can sponsor you, then you can get a green card even if you're out of status. The other family-based categories are this group of people will require a visa number. So there's limited number of visa numbers every year given out to these categories of people. And so the first one is unmarried sons and daughters of US citizen. These are, we're talking about majors, that is people who are adult sons and daughters of US citizens, minor children, spouses, and unmarried sons and daughters over 21 of green card holders, married sons and daughters of citizens of the US and their family members. So these are all different categories. F1 was the first one. Second category that we talked about was F2. F3 is married sons and daughters of US citizens and their family members. F4 is brothers and sisters of US citizens. So there's F1, 2, 3, and 4. And each category has a place in the visa bulletin, and each category has a cutoff date. So now the dates that are current for Indian nationals, the only dates that are current for Indian nationals are permanent resident spouse category. They have been current for some time. So take advantage of that because there might be a backlog in that category soon. The next, I guess, what I wanted to talk about was the process. Should we go into the process?
Before that, Ms. Reddy, before we move on to the process, since we're talking about who a sponsor can be and who are allowed to sponsor, there's a small question that we received. So the question says, my wife and I are aliens working in the US. My 1-year-old son was born in the US and is a US citizen. Can he file an immigration petition for us now?
No, as I said, the child has to be over 21 years of age in order to file. So you have to wait until he's 21. So you have another 20 years before the son can file for them.
Right. And there's also another question related to the same topic. I'm a permanent resident. May I file an immigration petition on behalf of my parents?
So there's no category which allows you to, as we went through all the categories, there's no category where a green card holder can file for their parents. They have to wait to become citizens. Then you will fall under the immediate relative category, the one that doesn't require any visa numbers, and you can definitely file for your parents at that point.
Right. Okay, so Ms. Reddy, moving on to the process of how can a sponsor file for a petition?
Right. So first, an immigrant petition has to be filed. Right. So that's usually an I-130. If the visa numbers are available, or if it's an immediate relative petition where visa numbers are not required, you can, if the person is in the US, you can actually file an I-130 and I-485 concurrently together. And both petitions get processed together, and there's a huge saving in time there. That usually takes about 12 to 18 months to process that. Now, if the person, either the visa number is not available or the person is in India, then you only file the I-130 petition. And once the visa number becomes available and once the I-130 gets approved, then you file an immigrant visa petition at the consulate. And before that, you're able to fill out the National Visa Center, NVC, actually contacts you, sends you an email, and asks you to fill out a whole bunch of forms online and submit documents online. And the forms and the documents are similar to what you would do in a 485. Once that is done and they have completed the process, the NVC sends all the information to the consulate. And then the consulate, and in this case in India, it's the Mumbai consulate that takes care of these things. The Mumbai consulate will schedule a visa appointment. We'll process, we'll again look at all the documents and we'll call you in for a visa appointment. You'd have to take medicals, meaning you have to do a medical test, and you have to get police clearance certificates and all your other documents. And then they will then approve an immigrant visa for you. And then you have to enter into the US within a certain period of time with that immigrant visa petition. And when you enter at the port of entry, so at the airport, they process all the documents. They take everything from you. Everything is in a sealed envelope from the consulate. They process it and they mail you the green card. They allow you in on the immigrant visa, and then you get the green card in the mail a week or two later, or a month later, whatever the processing time is. So that's if you're outside the country. If you're in the country, of course, as I said, and if you don't have a visa number available, then you just file the I-130. You have to make sure that you're maintaining whatever your status is, because you have to wait until the visa number becomes available to file your 485. At the time of filing your 485, you have to be in status. So filing an I-130 doesn't give you status. Filing a 485 does, but not an I-130. So keep that in mind. Say you're on a H1 or you're on some other status, L1, whatever it might be, you have to make sure you maintain that status. Now, if your visa number is available, you can file, as I said, an I-130 and 485 together. And you have to submit, you also can file a work authorization document, and you can also file an advance parole document. Work authorization allows you to work. Advance parole acts like a visa. It allows you to travel, especially with the family-based immigration. You cannot travel on your non-immigrant visa. If you're on a H1, if you travel on your H1 visa and you come back on your H1 visa, your 485 will get cancelled. So you have to travel on an advance parole. So there involves some period of waiting before that advance parole and EAD gets approved. So just make sure you don't leave the country or you don't work. Obviously, you can work on the H1 if you're on a H1, but you can't work on EAD. So we file these two applications concurrently with the I-130 and 485, and they're basically incidental benefits. So they're benefits given to you while the petition is pending. So there's, usually the processing time is 3 to 6 months, and with all the backlogs, sometimes it takes longer. It is taking longer nowadays. So just make sure that you're aware that, you cannot leave the country unless your advance parole is approved. So if you're filing for a parent, make sure they know that they can't travel for some time. Nowadays, in fact, the green card gets approved. It's happened. The green card is approved before the EAD, before they even get the EAD. So, or even get the advance parole. So the processing times are weird nowadays. There might be an interview here at the USCIS field office. For any family-based petition. For spouse petitions, if you're married, if you're filing US citizen filing for your spouse, interview is compulsory. And there's a presumption of fraud, meaning that you have to prove that it's a bona fide marriage to the officer because of so much fraud in that particular category. So you will get an appointment, a visa interview appointment letter if you're married to a US citizen and you're filing on that basis. Other bases such as parent, children, you may or may not get an interview notice. That's really up to the discretion of the USCIS officer. You might just get a direct approval. So that's the forms that are filed. That's the processing time. Now the documents that you have to submit are, the usual documents to show status, such as an I-94, I-797 approval, pay stubs if you're on a H1 or L1, and your passport copy, all your previous status documents. If you came on an F1, then all your I-20s, until the time that, you are filing everything, all your documents to show status. They want to make sure that you have not been out of status, and if you have, they want to know.
So, Ms. Reddy, We do have a question from one of our audience.
Go
Uh,
ahead.
the question is, hello madam, if my H4 I-539 is still in process, but spouse's H1 approval notice has arrived, can both of us leave the country for visa stamping or Dropbox? And this question is from Raj K.
So for the H4, you don't really need a H4 approval. You
Okay.
only need the spouse's H1 approval. So even if your H4 is pending, you can leave and you can go with your spouse to the consulate, and just by showing your spouse's approval, you can directly apply for a visa for yourself. So yes, the answer is yes.
Okay, I hope that answered your question, Raj. Thank you for asking. Yeah, Raj says thank you too. So, Ms. Reddy, please go on.
So as I was saying, the documents required, status documents, passport, your birth certificate to show, and your birth certificate and other document, whatever it is, to show relationship with your sponsor. So if you're being sponsored by your parent, then the birth certificate is proof. If you're being sponsored by your spouse, then you need the marriage certificate, and you need to show that it's a bona fide marriage, not a false marriage. So you would need to show other kinds of joint documents, joint bank statements, joint tax returns, proof that you're living together, etc., in case of a marriage-based petition. So these are some of the documents required. And so, as I said, the processing time varies. Sometimes it takes as less as 3 months, sometimes it takes 6 months, 12 months. So the processing times are really, up and down with reference to these kind of cases. So my suggestion is not to be in a rush. It doesn't take more than 24 months usually, but it could be faster. So that's the procedure and the
So, Ms.
processing
Reddy,
time.
as long as we're on procedure, I'm not sure if it really changes from a case to case, but we have a question pertaining to the procedure. So, this person says that I'm a lawful permanent resident and the step parent of my wife's child. What documents must I prepare for the immigration petition for this child? So, in this situation, does the document procedure change?
No, so you're allowed to file for a stepchild as well. So he's a U.S. citizen and he's applying for his stepchild.
He's a lawful permanent resident.
Oh, lawful permanent resident and applying for. Is he
Step
applying for his spouse
child.
first?
So that is not
Doesn't say,
mentioned
right?
here. Yeah, it doesn't say.
So if he's applying for his spouse as a permanent resident, then the child also is included with the spouse's application. So they come together. Both can be sponsored together because the child is the spouse's child. So spouse's family is included in that. So the document is relationship document to show the relationship between the mother and the child, to show that he is or she is the child of his wife. So again, you need to submit relationship documents.
Right.
And if you have adopted the child legally, then you come under the adopted child category.
Can this be a common RFE we might see in family-based immigration, Ms. Reddy?
If you don't submit a relationship document, then yes, you'll get an RFE. Otherwise, you shouldn't.
But what kind of RFEs do we see in family-based immigration probably? Are they different?
It could be lack of documents, like you're not submitting all the documents that I just mentioned. It could be that the person was out of status and they have questions about whether they maintain status or not. It could be a very important factor which I didn't mention, and part of the documentation is also sponsorship document, financial sponsorship document. So the sponsor has to be able to bear the financial burden of the expenses, etc., of the people that he's sponsoring. So it has to be, there's a certain guideline. So this rule of thumb, the spouse's income or the petitioner's income should be at least 25,000 or more for a family of 4. So, and there shouldn't be any other dependents. If there are any other dependents, that's counted as well. So they have to meet that threshold of finances, and say if they're not working and you submit a petition, then there will be an RFE. So that's an important document requirement as well. And the form that you submit to show that they're able to financially sponsor you is the I-864. So you have to submit that form along with the petitioner's tax returns, bank statements, employment letter, etc. So that could be a common reason for an RFE as well. And usually in those instances, say the spouse they just got married, young couple, the spouse is not yet working, then you can get a different person to fulfill the financial obligations and submit an I-864 on your behalf. So you could get, say, your spouse's parents, father, to submit that I-864 on your behalf. So, that's the workaround in those cases.
Right. So, Ms. Reddy, with that, we come to the end of the session for this week. And before we end, would you want to probably give us some golden advice before we sign off the show?
As I always say, family-based immigration is confusing, and there are a lot of nuances to the law, so don't try to do it yourself. Seek the help of a qualified immigration attorney to do it.
Right, definitely. Thank you, Ms. Reddy. Like always, it's a privilege to host you, of somebody of your stature, to come to our show and explain to our viewers the most important information regarding immigration. We're very grateful for. So thank you, Ms. Reddy. Thank you so much.
You're welcome.
You're watching Sakshi Live, and this is Thorn. Thank you.